Our next speaker is Ayelet Libson, a postdoctoral fellow at the David Berg Foundation Institute for Law and History in Tel Aviv University. I invite Dr. Libson to give a lecture about Behind the Fault Line, Transition in a Rabbinic Divorce Law.
Is it possible maybe to raise the microphone somehow? אפשר להעלות את זה? I did it myself. Okay. Thank you very much. It's okay? Yes? Thank you for the introduction, and it's great that I'm speaking immediately after Yael because my paper is, in a certain sense, prehistory of what Yael was speaking about, as I'll be talking about Jewish divorce law in the Talmudic period. So many hundreds of years before, but it continues to impact contemporary law, as Yael showed. One of the most dramatic changes in the history of family law was the introduction of the no-fault doctrine to the laws of divorce. During the 1970s, reform swept the United States and many countries in Europe, ultimately coming to be known as the no-fault revolution. Within a brief period, marriage in most of the Western world was transformed from an institution to be terminated only by the gravest of circumstances to one that may be dissolved at will. The transformation of divorce law enabled an easier process of divorce, such that in most Western countries, mutual agreement between husband and wife is now sufficient grounds for divorce. Moreover, the divorce reforms allowed for the emergence of unilateral divorce, whereby one partner may be awarded a divorce despite the absence of the traditional moral grounds of fault and against the objection of the other spouse. As the no-fault revolution swept Europe and the United States, the problems caused by the unilateral character of Jewish divorce laws rose to public awareness. The 1970s and 1980s saw a sudden surge of problems with Jewish divorce. The rates of divorce among Orthodox Jewish couples began to rise, and more women were restrained as chained women, quote unquote, due to their husbands' refusal to release them. More Jewish women began to develop feminist consciousness and created various organizations to lobby for a more egalitarian approach to Jewish divorce. As a result, beginning in the 1970s, scholars of Jewish law began to seek out those mechanisms within the Jewish legal system that resonated with the ideas developing in the broader culture. An increasing number of papers and books were written concerning one instance, and one instance alone, of Jewish divorce law, which demonstrated the possibility of no-fault divorce. This case concerns a woman who approaches a court stating that her husband is, quote-unquote, repulsive to her, and therefore she wishes to exit the marriage. According to one rabbi in the Talmud, this claim is sufficient for the courts to demand that the husband grant his wife a divorce. This argument later gained further traction in the post-Talmudic period, and for about 300 years was enforced in the divorce proceedings of medieval Jewish courts. Scholars have therefore often held up this Talmudic discussion as a precedent within Jewish law that might influence contemporary practice. However, I believe that the exclusive focus on this sole case exemplifying wife-initiated divorce or no-fault divorce has led to a skewed view of early rabbinic law. In this lecture, I wish to problematize the prevalent perception of rabbinic law and to offer a new perspective, arguing that the predominant innovation of Talmudic law is not in its development of no-fault divorce, but rather in its expansion of the grounds for divorce so as to balance a previously imbalanced system. As Yael already mentioned, one of the prominent characteristics of rabbinic law, and especially early rabbinic law, is its asymmetry. According to the Mishnah, the earliest corpus of Jewish law, compiled around 200 CE, men acquire women by means of payment. The marriage contract is signed by a groom and his bride's male legal guardian, women have limited inheritance rights. A husband has the right to annul his wife's vows, but not vice versa. Most importantly for our purposes, only men have the legal power to effect divorce. Divorce in rabbinic law is a unilateral action, instituted freely by a husband, with no need for the consent of his wife. In addition to the unevenness regarding the need for consent, the Mishnah further explicates the asymmetry between husband and wife with respect to the grounds for divorce. According to the accepted position in the Mishnah, a husband may divorce his wife for any reason he pleases, or, in the words of the Mishnah, even if he found another more attractive than her. What about the inverse situation? The Mishnah also lists the complaints that constitute grounds for divorce on behalf of the wife. First, there are instances where the husband takes a vow by which he deprives his wife of one of the basic terms of her marriage: food, beautification, or freedom of movement. Since he is breaching the terms of the marriage contract, he is required by the rabbis to give his wife a divorce, regardless of the wife's own wishes. A second category for grounds for divorce is that of physical blemishes. If the husband was afflicted by sores or other repulsive physical blemishes, he may be coerced by the court to divorce his wife. A third and similar category concerns the husband's occupation. If he works as a tanner or another lowly occupation, probably due to its odoriferous nature, he may be coerced by the court to divorce his wife. In all these cases, the grounds for divorce depend upon evidence that is objective and verifiable by people other than the couple. That the rabbis were willing to coerce a man to grant his wife a divorce on the basis of objective, verifiable evidence alone is manifest in a passage from the Mishnah that describes the historical evolution of early Jewish divorce laws. The rabbis describe how originally there were 3 claims that a wife could make that allowed her to initiate divorce and retain her dowry. Either testimony that she had betrayed her husband and therefore was no longer permitted to live with him, or one of 2 vows which would similarly prohibit cohabitation. So if she had taken these vows, she was no longer allowed to live with her husband. These claims all negatively impact a woman's personal status, and therefore, apparently, originally it was assumed that a woman would not make such a claim untruthfully. The Mishnah, however, goes on to record how the rabbis were concerned that a woman might wish to release herself from marriage simply because she, quote unquote, cast her eyes upon another man, and therefore they reformed the law to require the wife to either provide evidence to verify her claim or annul the vow to allow her to continue to live with her husband. In this passage, the rabbis reveal their objection to wife-initiated divorce. Although rabbinic divorce laws were already skewed in favor of the husband, even those claims that a wife could originally make were subsequently voided. What we are left with is a system in which a husband can exit marriage at will, while a wife must provide grounds that establish fault through verifiable evidence. However, rabbinic law continued to develop and was recorded in the canonical text of the Babylonian Talmud, codified in Babylonia in the 7th century. The Talmud consists of elaborate commentary and analysis of every point raised in the earlier legal corpus of the Mishnah. With respect to divorce laws, the Talmud introduces 2 major innovations. First, it broadens the arsenal of faults that a wife may introduce as grounds for divorce. Second, in contrast to earlier law that requires objective evidence to establish the wife's grounds for divorce, according to one Talmudic opinion, a wife can introduce subjective claims that trump the husband's claim and allow her to demand a divorce based on no objective grounds. Concerning the first development, Talmudic law recognized the addition of further grounds for divorce. For instance, Talmudic law allowed the wife to introduce a claim of the husband's impotence in order to initiate divorce. In fact, the Talmud rules that in matters that are between him and her, namely sexual matters, the woman is to be believed. The Talmud explains that the wife's knowledge of physical intimacy is more certain than that of the husband. The wife's claim is based on knowledge that is accessible to her alone, and therefore she is not only believed, but her claim justifies both divorce and financial reparation. This case, then, reveals the addition of a fault claim that was not included in earlier Mishnaic law. The wife is permitted to introduce a claim that is acknowledged as problematic because of its lack of objective, verifiable evidence, and yet this claim can provide sufficient grounds to initiate divorce. A closely related claim that a wife can present is introduced in the Talmud in an unusual manner. The Mishnah, the earlier source of law, presents a dispute concerning the commandment to multiply and reproduce. One rabbi holds that the commandment is incumbent upon both man and woman, while another argues that only a husband is obligated. The Talmud, however, accepts the ruling that the commandment is a man's duty alone, thereby preempting the request for divorce from a wife who was not blessed with children. However, the Talmud then goes on to introduce two stories of women who approached their rabbinic authorities with precisely such a request. They wanted to divorce in order to be able to remarry and have children. And in both cases, the rabbis accepted their concern that they would have no children to support them in their old age and justified their demands for divorce, ruling that in such a case the husband can be compelled by the court to grant a divorce. Once again, we see that in Talmudic law, the range of faults that a wife can introduce is expanded to allow her significant grounds for initiating divorce. Finally, we come to the sole instance in Talmudic law which seems to allow for no fault divorce. In the Talmudic passage under discussion, two rabbinic opinions debate the specific nature of what the Mishnah calls the rebellious wife. One opinion argues that a rebellious wife is only one who explicitly claims that she wishes to torment her husband, probably by not having sex, but does not wish to terminate the marriage. This woman is to be fined in an attempt to coerce her to return to her husband. In contrast, a woman who makes the claim, "He is repulsive to me," is not to be coerced to continue her marriage. The second opinion in this discussion, however, argues that even a woman who argues that her husband is repulsive to her is still to be coerced to return to her husband. Despite the fact that repulsion in the Talmud may actually refer to a physical sensation, commentators and scholars have mostly focused on the subjective psychological force of the "he is repulsive to me" claim, effectively opening the door to the wife's ability to release herself from marriage without the necessity to point to a specific blemish, and allowing her to initiate divorce by demand or no-fault divorce. Voicing dissatisfaction with a particular husband is a way for the wife to express her wish to dissolve the marriage, and therefore, according to the first Talmudic rabbi, it is inappropriate to coerce her to continue the marriage. I'm sorry, my notes are somehow all screwed up, so I will try and just summarize. Okay. What's important, I think, is to notice that the Talmudic discussion also has the parallel opposed voice, which doesn't allow leeway for dissatisfied wives to just initiate divorce on her own, but rather remains firmly in line with the earlier Mishnaic law, which wishes to limit the grounds on which a wife can initiate divorce. The discussion in the Talmud is then also followed by a very ambiguous story in which the Talmud tells how Mar Zutra, the rabbi who said that a woman can be compelled to return to her husband, actually did so when he acted as a judge in a court. A woman came before him and said, "My husband is repulsive to me," and he coerced her to return to her husband. And out of the union of that husband and wife, out of their conciliatory union, a great scholar came from that union, was born out of that union. So that seems to indicate that that's the correct way to go, to force a woman to return to her wife and not to allow the he is repulsive to me claim to initiate divorce. On the other hand, the Talmud then goes on to say, well, that was just a miracle. So it's not clear in the end of that story what is the actual ruling. What is the story trying to tell us about the ruling? And it remains somewhat open-ended. In sum, I would suggest that a survey of Talmudic law reveals one highly contested case of possible no-fault divorce, but the Talmud's main innovation in comparison to earlier sources lies not in its introduction of no-fault divorce, but rather in its expansion of the fault claims available to the wife as possible grounds for divorce. While the Mishnah works hard to eliminate any grounds that the wife might have and to enforce and strengthen the unilateral nature of rabbinic divorce law, the Talmud attempts to balance the scales by allowing the wife to introduce new grounds for divorce. This transition is also related to a shift from a requirement for objective, verifiable grounds that imply a deep suspicion of the wife to allowing the wife to introduce more subjective arguments, such as her wish for children, that go together with the emergence of the wife as a legal subject who can accuse her partner on more equal footing than before. The Talmudic system thus combines both fault divorce and possible no-fault divorce. I believe that the innovation here is that this model presents an example of how fault divorce can also be favorable for women. By allowing the wife to introduce fault claims, the rabbis correct the bias inherent in the early system of law that favors the husband. The innovation of Talmudic divorce reform was in recognizing the bias of early rabbinic law toward the husband and correcting that bias by broadening the claims that a wife might make so as to correct the imbalance against her. Thus, although I'm arguing here against the view of the Talmud as a progressive precedent to no-fault divorce, I believe there is still an important point here that can inspire the modern conversation regarding divorce law. In the wake of the widespread acceptance of no-fault divorce throughout Europe and the United States, scholars have begun to recognize how, contrary to its original intention, no-fault reform often ends up harming women. Because for the most part, men are the physically and economically stronger party of the marriage, no-fault reform often ends up awarding men and punishing women. No-fault reform has restricted courts' ability to compensate wives for husbands' injurious behavior. It has also eliminated the fault system's principal justification for post-divorce adjustments, the guilty spouse's continuing responsibility for the well-being of the family left behind. Modern laws often also ignore career assets, such as degrees, reputations, and earning capacity, typically acquired by the husband while the wife took care of their joint domestic life. Indeed, perhaps the most well-known statistic in family law as a whole revealed that following divorce, men's standard of living went up by 42%, while women's went down by 73%. These data have caused a backlash of critiques against no-fault divorce and multiple proposals to return to a fault-based system. On the other hand, some scholars have argued against the moral presumptions that would underlie a fault-based system. I would suggest, however, that perhaps the key point is to realize that, as Carl Schneider has argued, family law can never really be neutral. Instead, what is important is to recognize, as Talmudic law did, the biases created by social constructions and the need to develop specific legal mechanisms for correcting them. Thank you.